Ms. Ager, thanks for your testimony. Ms. Tamez, welcome. Introduce yourself and give us your testimony.
Yes, Mr. Chairman, members of the committee, my name is Laura Tamez, and I am a past president of the Texas Trial Lawyers Association. I've practiced for 29 years as a trial lawyer, and I'm here on its behalf and individually testifying in opposition to the bill. So I want to start by thanking Senator Schwartner for visiting with our president, Jack Walker, and I about some of our concerns with the bill. But I want to focus our attention to on Section 8, Subchapter D, the non-economic damages that start at page 20, and our issues in terms of Constitution violation. So Article 1, Section 15 of the Texas Constitution commands that the right to a civil jury trial shall remain inviolate. The U.S. Constitution provides the Seventh Amendment, which says that a right to a civil jury trial should be preserved. There are components of this bill that invade the province of the jury, which we find are unconstitutional. I want to turn your attention to the remitter portion. And remitter is just a Latin term for to be sent back. And it's essentially a reduction in an award that maybe is not supported by the evidence. There was a case in 2023 where the Texas Supreme Court had to review what it was said to be an excessive award. And that Supreme Court, it ended up being reversed and rendered. So the case was reversed. Rendered means you don't get to go back and get a do-over. But I want to quote what Justice Devine said. But even as we must acknowledge that damage awards may occasionally exceed the bounds of our reasonable expectations, we ought to have faith in the jury system. As part of that system, judges at every step of the way have an opportunity to grade the jury's papers and offer a remedy for excessive awards. And that's key because there is a framework in place that works. The defense lawyers at this table, very capable, are using those tools and those remedies in their courts of appeals. So let's look at the facts and the evidence in the bill, where on page 22, it starts with subsection A, except in an action in which another law limits recovery of non-economic damages. The word limits recovery in non-economic damages means there's a restriction of that amount, which is by definition a cap. And the framework of this bill is telling the judge that if the jury award exceeds an amount, for example, it's got some arbitrary numbers set by, I guess, the supporters of the bill. For example, $1 million in a wrongful death for pain and suffering and emotional anguish. If the award is $1,000,001, then that is subjected to reduction, to remitter. There's other numbers in here, $250,000 for personal injury. If it's $250,001, that is subject to reduction. These are arbitrary amounts, not rationally connected to any evidence, that are set in statute, where a judge is mandated to then be a substitute of the finder of fact, invading the province of the jury by substituting that judge's opinion as to factual and legal sufficiency of evidence. And that is one of the major problems of this bill, is you are setting guidelines and substituting the province of the jury. The remitter that we have in place today is working and is utilized. Any party, a defense or plaintiff, can suggest a remitter and reduce the amount of damages. It just happened in 2025 in the 14th Court of Appeals. There was a reduction of economic damages, both past and future. The trial judge can suggest a reduction of the amount. The Court of Appeals can suggest a remitted amount. The Texas Supreme Court, the ultimate guardrail in excessive award cases, can suggest a remitter and a reduction of the amount without requiring the judge to substitute its opinion. Every jury is told at the instruction, you are the sole judges of the credibility of the witnesses and the weight of the testimony of those witnesses. That isn't an instruction. The Texas Supreme Court has said we shall not substitute our fact-finding for that of the jury. So I will end on the last part, which, well, the arbitrary awards that are set out here. If the trial court is to give a statement, right, the trial court can still remit, but this is to give a statement to say that that is an excess jury award on its face without looking at the sufficiency of evidence, and that is the cap on the damages.
And thank you for your testimony.